So I'd like to introduce John MacDonald, who is our speaker today. John is the managing partner of Constangy's Princeton office. He's also the author of our state-specific New Jersey Human Resources Manual. So this is the first time I'm working with John, but I'm so excited. I mentioned this last week, these HR hot topics are my favorite. And I know wage and hour stuff is also a lot of people's favorite thing to talk about. Maybe not favorite thing to talk about, but one of the most important things to talk about. Is that fair, John?
Yes, very fair.
Anyway, welcome so much. Thank you so much for joining us today.
You're welcome. You're welcome. Well, I couldn't not accept, given the name of the topic today. Oftentimes when you see something like hot topics and various types of law, there might be a little bit of overselling there. I don't think there is this time. I've been doing employment law since 1991, and I don't remember ever seeing the flow of change and new law and new developments at the same pace as the last few years. So it very much is an area of hot topics. I think it will continue to be there. So I'm happy to come and talk about these particular topics. We're going to cover really everything from some catch up on wage and hour to, I think we even have time to talk about some Supreme Court developments with affirmative action, for example. That one came out. But I would say just stay tuned to HR Simple. Stay tuned to the changes that are going to be happening soon, because there are a lot of them coming down the pike. Even things which seem not particularly interesting, like the Chevron standard, which is going to be up for grabs in front of the Supreme Court coming up really anytime near the end of the year, which could turn a lot of things on their head regarding the administrative law and the ability of agencies to interpret their own statutes, and lots of things up for grabs. So I'm happy to be here. I think we can do questions as we go. At least we can start doing that. But we'll move right along. And if you have questions, Amy's standing by at the chat. As Amy said, I'm the Princeton partner of Constangy. I am licensed and have tried cases in those 4 jurisdictions: New Jersey, New York, Pennsylvania, Connecticut. Not going to limit what I'm talking about today, obviously, to those 4 jurisdictions. But if anyone has any jurisdiction-specific questions, I'll try my best outside of those 4 states to answer. Constangy does, we do employment and labor on the management side nationally. Before I really get into the meat of the presentation, I wanted to just touch on a question that a lot of people have had for me over the last few years, at least since COVID started, which is based on a lot of the changes that remote work is bringing, and whether or not that has slowed down employment litigation in general. A lot of us thought it would, because of obviously the remote aspects of work, and it really hasn't. So if, just as a macro question, if we are asked if remote work, if COVID has slowed down the pace of things like EEOC filings, for example, it hasn't. Many people were surprised to see that. We thought that doing most of our work remotely and on Zoom calls and whatnot would slow things down. It hasn't. This little slide here shows you total charges in 2020 at the 67,000 mark, and then it did dip down a little bit into COVID there at 61,000, and then the total charges for the year 2022 last year bounced up to 73,485. So nothing has slowed down, certainly in the area of employment litigation. In fact, the EEOC is introduced, as a lot of agencies have, new programs which make it easier, facilitate claims to be filed. The E-Race and LEAD, for example, they're very good platforms in terms of moving complaints along, getting them initiated, getting them litigated. So I think we can foresee, with the increased ease of filing complaints and the handling of complaints, not only at the EEOC, but in many agencies, that we're going to see increased litigation as we move to the next few years. All right, I want to go back to some basics on wage and hour compliance. Amy says that's a favored topic of this group. So I thought I'd get back into some basics, then to give you some updates, and then tell you what's kind of on the edge, and what we're looking at now to try to predict, get ahead of things. These four basic issues are what we're always dealing with in wage and hour, which is the essence of which employers are covered, which employees are covered, and to what extent. Then the question of compensable hours and overtime. What does overtime mean in the context of remote work, for example? And then, of course, the area which has been an area which we continue to fight over, and will be an area not only for litigation, but also for, I would say, some legislative developments would be in the exemptions to overtime. It's a good idea to kind of back up a little bit and remember where all this comes from. What's the framework that that we have to interpret all of this in wage and hour? And it really comes down to two federal agencies, and then of course the state agencies. But on the federal end of things, we have the FLSA and the Department of Labor. As it says in my slide here, FLSA. If that's used, if FLSA is going to be your problem, then you're looking at some significant damages, more than if, say, the Department of Labor is coming after you. It's two different tracks, but depending on which agency, which statutes you're dealing with, the response is somewhat different. The budget for the Department of Labor on wage and hour has been significantly increased, and I think that's going to continue as we go into the next few years. So $61 million in an increase doesn't seem like a great deal of increase, but for that one division, that is pretty substantial. So this area is an area of resource for the government in terms of making money for the government. So enforcement like this is generated by a desire to make the most of its power to find error in business, and to assess fees, and to make some money for Uncle Sam. Here's an easy one. So talking about the minimum wage. So this is a topic that's kicked down quite a bit. It's probable that you'd see this federal minimum wage increase. It doesn't really mean that much here, but the federal, here meaning in the mid-Atlantic, the federal minimum wage is really your floor. So whether you're dealing with, well, for FLSA is really the floor that all the states have to comply with. Each state, for example, New Jersey, can exceed, and of course does exceed, the minimum requirements of FLSA, including the minimum wage. But there are some states I'll mention here in a little bit, which actually do use the federal minimum wage or close to it. And as the federal minimum wage may be increased, those are the states. If you're in those states where your minimum wage is significantly below $10 an hour, that's where you're going to see some pressure on the state legislatures to move those up. Many minimums in states moved up this year. I know in New Jersey, we've had a rolling increase, and the federal minimum wage at $7.25 per hour. It's not used by many, and it's certainly not used in many states. Yes, this is my Chris Rock reference. So for those of you who can't see the slide, it says, I used to work at McDonald's making minimum wage. You know what that means when someone pays you minimum wage. You know what your boss is trying to say, quote, hey, if I could pay you less, I would, but it's against the law. So that's in essence what we're dealing with minimum wage. So apart from FLSA, what else do you have to look at? Again, the FLSA for minimum wage is going to be your floor, things that you have to do, minimums you have to do. As I said, most states exceed that floor. FLSA does not preempt state law. So it's the bare minimum. It's for these purposes doesn't mean a heck of a lot. FLSA has a lot of strengths and uses in other areas of wage and hour law, but for minimum wage, you really look to your state. These states, I have New Jersey here, for example. There's a comparison just so you can see how different some of them are and the extent that some of them are different. So New Jersey, for example, at $14, $13 an hour, closely parallels New York, a few cents more in New York. Pennsylvania, strangely, very low, down to the federal minimum wage, along with Georgia and Alabama. And then we look to out west to California at $15.50. So there's a huge variation in the states, but even in the states, just be careful because there are states that'll have certain city requirements on minimum wage, and those can go through in a jurisdiction you're really not paying attention to, but you may have some labor over there, and you need to be up to date on that those increases before they happen, or you could look at various fines and getting in trouble, etc. So you will need to. This is rather obvious, but you need to comply with the wage and hour laws of the states where your employees work. So this may lead to a question in the chat, but we've spent the last year or two struggling and fighting over issues about remote work. Where does the person work, for example, if they spend half their time here and they spend half their time in another state, or they travel frequently and they never come into an office anymore, things of that nature. But the general rule, and again, I'm generalizing here, but the general rule for wage and hour anyway is going to be that the state where the individual is working is the state where you need to be compliant. And if the city where they live has a slightly higher rate, then obviously you have to comply with that as well. Yeah. Okay. So one of the big differences between the state regulations on wage and hour and FLSA is that the state laws, by and large, go far beyond it in terms of specificity. So, for example, as it says in the slide, I'll just use the example of vacation actually, because that's low-hanging fruit. Vacation and PTO obligations as wages. So many states handle this particular issue very differently. I'll use New Jersey because I'm in New Jersey as an example. But in New Jersey, vacation, for example, it's an earned wage if you have, as the employer, a vacation policy, which is established, and the employee is of course relying on that vacation policy. However, you can have a policy which says that the vacation pay is not payable on termination. So you really live by the sword, die by the sword in New Jersey on your vacation policy, your stated policy. Other states don't work like that. Other states will find that it is not an earned wage, or they will find that it is an accrued earned wage that must be paid regardless, and you cannot have a policy which would exempt the employer from paying that out upon termination of the employee. Other areas of wage and hour that state laws cover that the FLSA doesn't would include obviously things like rest breaks. So New York and California are really the high points of rest break issues. New York has an extremely detailed schedule for rest breaks. California has one as well, and those particular areas are ripe for things like class action litigation and collective actions. And that's in California under the PAGA statute, that's something that you see quite a bit. As I say here in the slide, it often leads to wage and hour litigation. Yes, it does, because things like meal and rest breaks, for an example, if you do it as to one, you're probably doing it as to 1,000 employees. So it's a very easy place for plaintiffs' attorneys to look if they see a violation, a statutory violation. It's attorney's fees. It can be liquidated damages. It can be many things like that. So this is a ripe area for litigation, and it's an easy area to make mistakes. So you want to pay particular attention to the states where your employers are in, that wage and hour law, in addition to FLSA, of course. Another area that's pretty ripe and has been up for grabs over the last few years is the question of what is an employee, dual employment concepts, and employment versus contracting. So I want to touch on all of those. In particular, well, I should say that both dual employment and the contractor versus employee question have been litigated very frequently, and I know that the federal DOL and many state DOLs are extremely aggressive on the question of employee versus third-party contractor. But on joint employment, that has been an issue that we actually are litigating right now with respect to, there's a case, the NCAA case involving student athletes is something that we have been litigating in the Third Circuit in Philadelphia, and it goes to the question of what is an employee, who has control, et cetera. So I want to touch on a few of those fundamentals here. The test at the federal level has been changed. There was a test under the Trump administration that goes to, as it says here, the nature and control of the work and the opportunity for profit and loss. That that was part and parcel of a multi-factor analysis that I have on this particular slide that was changed by the Biden administration. So I'll get into that in a moment. But the multi-factor contractor analysis goes largely to, I would say, control. That's the last bullet point here, nature and degree of control. It really should be the first bullet point because that's the one that everyone really focuses on. But again, this goes to the question of whether or not you're a third-party contractor or whether you're an employee, because as an employee, that's taxation, that's you're regulated by the Department of Labor at that point, that employee, and that has been an area of much fines and litigation by the Departments of Labor in New York and New Jersey and Pennsylvania for several years at this point. As I said before, the current administration has changed the joint employment rule under what was then I call it the Trump rule, but this was the test for whether or not you had a joint employment. So, do you have the power to hire and fire employees? Not necessarily that you were doing it, but do you have the power to do that? Does the entity control your work schedule, the conditions of your employment, and does it do it to a substantive degree? Rate of pay, method of payment is part of the test. I haven't seen that really be litigated that much. Maintaining employment records, surprisingly, is something that is looked at. So, for example, if this often comes up in franchise litigation, if a plaintiff's attorney is trying to find control by the franchisor, for example, they'll often ask us, well, where are the records of Mr. Jones's employment? Where are the tax records, where are the employment records, et cetera. If those are all kept at the franchisor, then that becomes a factor in favor of finding joint employment by the franchisor. So that was the Trump rule, is what I'm calling it. This actually mirrors pretty closely the state rules that in the Mid-Atlantic, and I believe most of the country, at the state level. This became the new rule, so it's a much looser rule. I'm sorry, I'm ahead of myself. This slide goes to various factors that show that you don't have. So this shows factors that would not necessarily indicate that you have a joint employer relationship. So, as I was just mentioning franchising a moment ago, just because you have a franchise business model does not make you a joint employer, and no one is really arguing that at this point. Providing a sample employee of a handbook to a franchisee, that's another classic example. I would say that doesn't necessarily create joint employment, but it's an area of some significant risk. Allowing an employer to operate a facility on company's grounds, that in itself isn't going to create any real issue there unless the control of the company grounds somehow invades the employment, and then there's a control issue. Jointly participating with an employer in an apprentice program, really nothing there. Offering an association health or retirement plan to an employer, participating in a plan with the employer. These kinds of things, it once had some sway, but they no longer do. So simple participation in a plan like that is not going to create joint employment. So here we come to where I was going before, which is the proposed joint employment rule by the current administration. You may have heard of the economic realities test. That's what this is going to. This is a much looser test that the current administration wants to use in order to, again, the government generally wants to find employment as opposed to third-party contracting, and it wants to find joint employment where it can. Do the two employers share a co-determined matters governing the essential terms and conditions of employment? Again, they're talking about control. It's a little looser, but the issue of control is front and center in this test. The actual exercise over control is not needed. That's where this really is much looser than the test that was being used under the Trump administration. The ability to, the ability to exercise influence sufficient to change rules that would affect the employees' day-to-day activities, things of that nature. So there's not a lot of change here except for that one middle point, which is they're getting away from a strong control requirement, and that gives you obviously questions of fact, areas that can be delved into, and it's a much looser test, I would say, is a fair way of putting it. That's probably going to be what we're looking at for the next few years. Okay, so this is a slightly different area of wage and hour, and it touches on something I was mentioning before on remote work. Technology and devices are kind of the new frontier for issues of not only minimum wage payment, but overtime payment as well. And what it really gets to is the question of if you have an employee who is, the easiest example is working remotely, they're working different hours, they're working looser hours, they're communicating with other people at odd hours. And what happens is the Department of Labor or the state level or the federal level is saying, hey, wait a minute, if they're doing work, even if it's outside of their technical work hours, it's still work. So that's becoming an area where you want to tighten your seals as much as possible. And I think the general recommendation for something like that is just have strong policies and follow them. So if you have an employee, for example, that is constantly communicating or doing things outside of their regular hours, which is tripping close to getting into overtime territory, or something else that you don't particularly like, you do need to pay them for that. I think it's the general safe way to go. Your remedy is to discipline them for that. So if you have for example, a policy that says, don't communicate with other employees, after 9 o'clock at night or 5 in the afternoon or whatever the case may be, and this person's constantly doing it, then you want to discipline them for breaking that policy, as opposed to just not paying them, because not paying them will get you in trouble with the Department of Labor. Disciplining them for not following your policies will not. The other issues that this raises is it's privacy on mobile devices. Let me go back here. Difficulty in tracking and recording time. When it's off hours, when it's done remotely, it just becomes a real headache for the folks who are tracking hours. There are some new developments that in technology which make that much easier. For example, a lot of companies will have login times, and they can almost, I don't know if they're seeing keystrokes, but they can know with some certainty by task or by login when someone is working and when they aren't. That's helping solve the problem. But again, I would just be wary if you have people who are working outside of the expected schedules and areas to make sure that you correct them on that. All right, so moving on. Yeah, the new of, should have type standard. This is what I was getting at. So this is an example here of if the employer knows, for example, that X employee is constantly calling their supervisor or communicating with other team members off hours, trying to pull them into discussions about work or not work, whatever the case may be. If you see that happening, that's where this new of, should have standard comes into play. The Department of Labor, whether it's state or federal, is going to expect you as the employer to not just sit back and once you're aware of it, they're going to expect you to take some action. So it's not something you can ignore. So here's another example of that. So the example goes, employer system tracks when when employees are active on a computer. The supervisor, while working on a weekend, frequently sees a non-exempt employees active, and we have a printout of the time spent on the system. So if you have the ability to see the person working when they're not supposed to be working, particularly when it creates an overtime issue, then you will be charged to have the knowledge. You will be expected to take some action to correct that. And these are some tools you might use to correct the problem. Can you limit the physical devices that you give certain employees? Can you buy technology which allows you to either block work or to track work? They've got an implementation of rules, which is what I'm talking about, which is to set up a rule when you see the problem happening and not wait for it to become a problem down the road. And you can get a certain amount of buy-in from your employees on this as well. It doesn't have to be a one-way street. Following up on what I was saying before, and you all know this already, but the issue of on-call time. So you have an employee that you expect to be on call for certain hours during the day to take care of things as needed. This is another area of wage and hour that gets quite a bit of litigation. Generally speaking, when you have an employee on call and they do some work, you pay them for the time that they actually work. I was thinking about giving some kind of rule or some kind of standard for this. There really isn't. So you want to look to your own state wage and hour laws to determine whether waiting time, preparation time, things of that nature are going to be compensable. Here's some factors that often play into that particular question. And I'm not going to read them all directly from the slide because you can see it right there. But I would say most of these are going to go to the I would say the burden on the employee, and how close do they have to be in contact, how vigilant do they have to be, et cetera. The closer you get to the employee literally standing by for something on call, the closer you are to having to compensate them for that time, I think is a good general rule of thumb.
Hey, John, before you move on to the next slide, I got a question submitted just now about overtime. So somebody's asking, can we mandate overtime?
I would look to your state rules on that, but in general, I would say that yes, if you want to, if your work requires that someone puts in those overtime hours, there will be circumstances where that is not going to be allowed, I suppose. But generally speaking, yes, I would say that you can do that. Yeah.
Okay. Awesome. Thank you.
I would say most likely in most circumstances you're going to be able to require it if it as needed. But you want to check with your state law to be absolutely positive of that, particularly if you're in California.
Awesome.
So on the habit, we're getting to overtime, so it makes sense to talk about exemptions, I guess, at this point. So the exempt and non-exempt question is really, are you exempt from overtime, or are you subject to overtime? And is where we're headed now. So this is the basics on the exemptions, and the questions in exemption rules I have listed here. Generally speaking, it's going to be something a lot more basic than this. There are 5 essential exemptions that I think most people are familiar with at this point. And for those of you who are not watching this, it's the executive, the administrative, the professional, the newish computer one, and the outside sales exemptions. So these are the 5 categories where there'll be some exemptions from overtime. You're going to have employees that are working easily, say the executive, for example. Many executives are working 50, 60, 70-hour weeks, and they're not going to be obviously available for overtime, or they will not be entitled to overtime because of the exemptions. So the called the white collar exemption. So this is really just the executive that we're going to be talking about. There have been changes over the years to the salary caps and things on that basis, but they're really looking at 2 things. So what does this white collar employee do, this executive level employee do, and which is this, their duties test. And also there are some basic minimum caps on compensation. So even if their duties may look very white collar in terms of what they're actually doing in performance of their work, you can't use that if you're not paying people enough to meet the exemption. So here's basically an outline of the various white collar exemption bases. And this number here, the 684 a week, this of course changes on a fairly regular basis. In one direction, it goes up. So you have to, the exemption will only be available if that person is paid that much per week. There's a case I'll talk about later that actually interprets that. It's kind of an interesting issue, but by and large, you need the pay, you need the person to be operating at a level of control in the organization that is generally associated with executive level job duties. The easy one here is the employee must customarily or regularly direct the work of at least 2 or more other full-time employees. So that's kind of a minimum. You get the right pay, you get them managing 2 or more people, and you're in the exemption for all intents and purposes. Hiring and firing is important. I would say this is one where you might have to watch a little bit, because these days there's a lot of I would say not pushback, but it's unclear who has the right to hire and fire unilaterally. So that's a little particular area of weakness if you're trying to defend a white collar executive exemption. And what I'm getting by that, Amy, is sometimes the manager will have the ability to fire, but in conjunction with HR, for example. So then, do they have the unilateral ability? Sort of, but not entirely. So if there's a little check and balance there, that exemption might come into risk. And you want to look at these periodically, by the way, to make sure that your employees are fitting these exemptions. Here's the administrative exemption. Again, there's a minimum pay rate there, and then the exemption goes to people who where their primary duty is the performance of office non-manual work. And here's the key: it has to directly relate to the management or general operations of the business. And the point of contention is the last one here, which is the primary duty includes the exercise of discretion and, importantly, independent judgment with respect to matters of significance. As you can see, that's a pretty vague definition. And that's why this is an area where that exemption gets challenged quite a bit. These 2 are exceptions to exceptions. So inside of the executive exception, there's the professional, learned professional exemption, which is why you can have lawyers working very long hours, among other things. This goes to the special degrees, advanced knowledge and science or learning, et cetera. So you probably know who these folks are, but that learned professional exemption is alive and well. Creative professional, we have a strike in California right now that involves quite a few creative professionals. They would, for all intents and purposes, if they were employees, fall somewhere into this creative professional exemption, which would get them out of overtime theoretically in the right circumstances. And then this one, which can developed, I think, in the late 70s and early 80s, the computer employee exemption. I won't go into that in detail because I'm not a proficient computer technologist by any stretch of the imagination. But the areas where this has really been fought have been in independent contracting / employment, employees being seconded by independent contractors to corporations. There's been certainly some allegations of abuse in that area over the past 10, probably 20 years at this point. And then lastly, the outside sales exemption. I think most people are pretty familiar with this one. Outside meaning that it's very independent. It says customarily, regularly engaged away from the employer's place and places of business. That's really the key. So if you have sales in your headquarters, they're not going to qualify for this exemption. This is what we used to call a drummer, or someone who has a territory out of state, things of that nature. So there's a certain amount of independence with the outside sales person from day-to-day supervision, certainly. Yeah, as I say in the slide here, inside sales continues to be a big deal. It does, and there, as you can imagine, there's a lot of gray between an inside sales position and an outside sales position, particularly now. So get a few cases here, talk about the exemption issues. This one, Helix, it's a fairly newish case. And this one was interesting because it turned on the salary requirement, and what was happening was it's a little bit technical, but in essence, it was not only that you have to pay X, but you have to pay. You say you pay this rate, which is 684. You have to pay it consistently and over a substantive period of time before you can take advantage of the exception. So if your employees who are possibly in that exemption haven't been there that long, or there's some fluidity to what they do and how they get paid, et cetera, they may or may not fall into that exemption, which is what the Helix case was about. This wasn't something that came up very much before, but given a lot of gig work and I mean, this dealt with an offshore oil facility, is my recollection, but it's becoming more and more of an issue when you have work that isn't clearly defined, or employees that are doing different tasks and different rates and things of that nature. So as I mentioned before, the rate is what frequently goes up here on the white collar exemption, and there's the new number for us proposed. Possible duties changes, yeah. So the rule I'm referencing here, the hard 50, that comes out of the question I was just talking about, which is, are you really engaged in that kind of activity for a substantial amount of time? So the hard rule I'm referencing, which is coming out of California, is it really needs to be your primary duty, and they're defining primary duty as at least 50% of your time you're performing that exempt work, in that capacity. So what can you do as things move along? It's a bit of a double-edged sword. I think that you want to continually look at your exemptions. If you're an HR, you want to not let the business side just forget about the exemption issue, and periodically take a close, hard look. Because if you get it wrong, especially over a long period of time, you can have some significant consequences. The reason I say that is a lot of states are expanding the lookbacks on these types of violations. So for example, New Jersey went from 2 to 6 years in terms of a look back. So if your exemptions weren't right and you did it for 4, 5, 6 years, throw in the statutory issues and penalties and whatnot, it can be a very significant issue for any company. So I would keep an eye on the rate changes for the exemptions, the executive exemption for the administrative exemption for example. I say to look at the duties test for close calls. We just talked about the primary duty issue and the hard 50% thing. So you want to get a look at those. And as people move through organizations, they get advancements, they move into managerial positions or out of managerial positions, things change, and you want to periodically audit those to make sure that from the exemption point of view, you're correctly identifying people. Lastly, on here, it says consider law change an opportunity to address challenging exemptions. The reason I say that is there's a certain amount of leeway when there are legal changes, when there are statutory changes that the Department of Labor will probably give you. If, for example, if something definition changes or something in this area of any substance changes, if you do a good faith look at your exemptions and how you're treating people and make changes at that time, then not only are you avoiding real problems that could come down the pike later, but you're going to buy a little goodwill with the Department of Labor because they can see that you're acting in good faith. You made an effort, and that goes a long, long way. The reason, by the way, it goes a long, long way is because most of these statutes will have a willful penalty. So if they determine that your wage and hour violation was willful, and they will interpret that very loosely, then you could be looking at double or triple damages and penalty damages and all sorts of things. So showing that you're a good faith player makes a big difference to the state and federal DOL. Exemption action. Okay, we just talked about things you could do to take a look at your exemptions. Yeah, I think in terms of fluctuating work weeks, yeah, if you have new types of employment you're working with, remote hybrid work, anything that's new that you put into play during COVID or in the last few years anyway, and it's creative, it may not be compliant. So take a look at that. It's a fluctuating work week, for example. Yeah, take a look at what you're doing. If it's something that seemed very clever at the time, you may want to take a conservative look at that and just make sure that you're in compliance. All right, let's go on to our legal trends.
Can I ask
Sure.
one question before we move on? So somebody just submitted a question that says, if an hourly employee fails to submit all their hours on time, can we make up the difference on their next paycheck?
An hourly employee?
Mm-hmm.
Yeah, well, if it's hourly exempt, I would say maybe. FLSA is not going to let you do that on a salaried employee. If they're purely hourly, they're hourly exempt. I would have to check on an hourly exempt. Yeah, that's too close to the line for me.
Okay, I think that they're just straight hourly. Yeah,
no, straight hourly, you should be okay. What's the circumstance of the why they missed the time?
It seems like they failed to submit all of their hours. They submitted some of their hours, but
okay, I take it back then. I'm sorry. No, under those circumstances, right. That's a great question to answer because it goes against common sense. So the common sense answer would be, well, wait a minute, of course you can. If they hadn't worked the hours and they're supposed to work the hours, but they didn't work the hours, then you'd be in a position not to pay them, obviously, for the hours they didn't work. But here, where it's a different circumstance, they did work, but they failed to write it down.
Yes.
You still have to pay them. So you have to pay them. The remedy is discipline for that. But yeah, you definitely, I can't speak for all 50 states, but I can't imagine there's a state where you would not be required to pay them, and that the Department of Labor of that state would say, okay, look, you can fire them, you can suspend them, you can do that kind of thing. But if they worked, you have to pay them.
And can you tack it on to their next paycheck, or do you have to pay them separately for that to make up that time?
Well, if you're aware that they worked at the time that the issue arises, then you should pay them in that pay period. If you see what I'm getting at, so if it once it comes to you, once you're aware that they worked, then you need to pay them in that pay period. To make all reasonable steps to pay them in that pay period. If it rolls over the next pay period, if you probably have a good excuse, but you couldn't penalize them by not paying them until the next pay period is what I'm getting at.
Okay. And you think that they should get something in writing that there's some disciplinary action so it doesn't happen again?
Yes. No, absolutely. Absolutely. Yeah.
Great.
Yeah. And then just take steps from there. But yeah, I mean, that's kind of a general good rule of thumb when you're dealing with wage and hour, is that if work is performed, et cetera, it's, the choice of the employer, the remedy for the employer is going to be on the discipline side as opposed to the withholding side.
Sure, that makes sense.
So, and that goes to things like payroll deductions, things like that. Just don't do it. It's a bad idea. There are almost all the states will have very limited circumstances where you could do a payroll deduction. You don't want to be on the wrong end of those.
No, definitely not.
Good. Thanks for the clarification, because that made all the difference in the answer.
Yeah, it was a good question.
Yeah. Yeah. Okay. So where are we going? Yeah. So we've got a lot of developments in the area of protected classes. This was a particularly interesting outcome here in this case. So I'll just leave the slide up there, but this particular one, the Bostock's, this actually went a different direction than some of us thought it was going to go. So keep an eye on the Supreme Court, because they are sorting out some rather difficult issues they have in the area of LGBTQ and EEOC. We just have to keep an eye on where these things develop as they kind of get sorted out over the next few years. And there you have it. So this next slide, this is guidance from EEOC, and I'm sorry for people who can't see it. It's on the issue of guidance for LGBT plus workers. The EEOC got perhaps a little ahead of itself here in this guidance. They certainly wouldn't think so, but we were operating with that guidance because there was nothing else to deal with. And then what happened in this Bostock case that we're looking at is Supreme Court had laid down what the EEOC thought. Well, let me put it this way: the EEOC read it differently, read it much more broadly than the Supreme Court, and then the Supreme Court then this federal judge in this case kind of reeled this back a bit here, without getting heavily into the specifics of these cases. There's some tension now between not so much coverage under Title VII, Title VI even, but the issue of what the standards are going to be for determining the employer's decision-making process and what was the driving factor in the adverse employment action, et cetera. So these are very, very interesting cases that are kind of working their way along. And I think over the next few years, we're going to see more guidance from the EEOC as they play a little bit of leapfrog with the Supreme Court on some of those questions in the employment context. This is interesting. So talk about new topics. So artificial intelligence it's reared its ugly head in the legal world. And well, it wasn't really this year. I guess it was last year that things really got exciting. But May 12, 2022, EEOC puts out its first guidance on AI. And what the issue that had led to that was that AI, which is very useful for certain employment metrics and determining metrics, was being used to select candidates and make effectively decisions, or at least recommendations for employment. And the EEOC was very concerned about that. So their concern was that AI was not discriminating against people or disadvantaging people. And because of course AI only does what it's programmed to do, it became an issue of concern about outcome that the EEOC had. So they put out this guidance, and I'll talk in a moment about something developed from that. But these are the three areas of concern under ADA, and I also say under FMLA, I think. But that the algorithms were picking up. So EEOC is worried about three things. Should there be a process for reasonable accommodation that is being evaluated, or is it really being appropriately evaluated in the AI context as opposed to a human HR professional? And how do you know if that's really happening? The next concern was a concern about whether workers with disabilities evaluated by AI were not being screened out because of whether they could do or not do with an accommodation particular tasks the job required. You can see how hairy this gets in the context, especially of physical jobs that have physical requirements. And then the last issue really related to what information was being gathered and used, and then I guess more to the point, the decisions the AI was making on what that meant in terms of the candidate's potential ability. So these are all really good concerns, and I think well-placed concerns, because it's unclear to an investigator. Say you're in the EEOC and you go to company X and they say, well, we use this AI program to select these 5 people. It's very unclear to the EEOC investigator why those decisions were made. I mean, they have some sense, but you know, what went into the programming, for lack of a better word, that resulted in these candidates, as opposed to if we went to a hiring manager or a screener or an HR screener and said, well, you know, why did you look at Jonesy? And they would say, well, because we like the fact that she can do X, Y, and Z. The program, the AI output isn't going to give you that. It's not going to be easily seen what the bases are. So I don't have a slide on that, or I don't have a slide on that, but there's Amy and I were talking about this before we came on, but New York City very recently has established rules on this. I expect that that will be throughout the country in short order in terms of dealing with this particular issue. But if you have any New York City employees as of last week, then there are rules that you need to be concerned about using AI for these purposes. I can't tell if the audience is using that or to what extent they're using it, but it is the use of that was growing exponentially and has been growing exponentially, and that's quite obvious. So on to more protected classes. So This won't come as a big surprise, but gender dysphoria has been determined to be covered by the ADA. This example, the Williams case, was an inmate case. It was interesting. I won't read the slide, but it follows a pattern that we were expecting. So there's really nothing that was too unusual in that development. Oh yes, this was a good case. Okay, so there's another case. Speaking of the ADA, which I thought was interesting. And the reason I raised this Harkey case. So basically, this is the sleepwalking case, and the facts relevant to this discussion are pretty straightforward. So termination of an employee who, while sleepwalking, she wandered into a coworker's hotel room. I believe they were on a business outing, half naked, and fell asleep in his bed. So the employer terminated, and of course the ADA action ensued. So somewhat surprisingly, the court ultimately decided that they could fire her, and it was because it wasn't because they fired. They said they didn't fire her because of her ADA issue, her sleepwalking. It's because of the end conduct that resulted from that. That's a little bit of tail wagging the dog, I think, but I'm not on the court, so my opinion doesn't matter that much. But the reason I bring this slide up is that there are pushbacks in various areas of the country on ADA issues. It's not a complete one-way street when it comes to the expansion of ADA rights.
That is a wild case.
It is a wild case. It's really interesting.
Yeah.
So I mean, it really if you really take it to its logical extremes, it would mean that really any bad thing that happens as a result of your handicap or your medical issue, which you did not intend,
Right.
can be used against you. Right. So something you had no intent to do can be a valid reason for termination. It's certainly an interesting decision.
I'm really surprised by that. Yeah, we've got one question in the Q&A. Do you want to go through this first, or do you want to answer it first?
Let's do the question.
Okay, so it just says, can you explain more about day-by-day overtime versus weekly overtime versus weekly total overtime?
Yeah. Very useful question. The import as well. Do we do it? Is it 8 hours plus per day? Is it 40 hours plus per week? I would say look to your individual state to be certain on that. FLSA has its base, but I would look to your individual state on that, because they will vary on that.
Okay. And do you think it's appropriate to, whenever you find that answer out, depending on what state you're in, do you think that that's appropriate to put in an employee handbook or in your policies somewhere?
No, I don't. As long as your HR department's aware of it. I think the only question that comes to my mind, well, actually, I'll take that back, because if you have a policy that says, for example, that you can't have unauthorized overtime, or any overtime must be pre-approved or something along those lines, then it's only fair that the employee know when that overtime is going to start accruing. Yeah. So if you're in a state where it's, you have to, work X amount of hours to start digging into overtime, or it doesn't accrue until X, then depending on what's your work week, those other factors, then they would need to know that, because otherwise it'd be unfair to charge them with failing to follow their policy if they wasn't clear what the policy was. Yeah. So I think that's fair. Yeah. Okay. Cool. Back to, this is religious claims. So we're hitting all of the high marks here on developments. Religious claims have been relatively quiet, but they came back with a roar recently with the wedding cake case, the Supreme Court, and there have been a few like that. This particular case, this Kroger case, actually went the other direction. I shouldn't say their direction, but it wasn't an expansion so much. So this case, you had Kroger, they had aprons, and they wanted to wear rainbow hearts, or the store wanted them to wear rainbow hearts, I think during Pride Month or something related to that. And so the employer doesn't want to do, the employee didn't want to wear it, or employees, I should say, didn't want to wear it. And Kroger, the employer, fired them for failing to follow the directions to wear this on their aprons. And the court said, no, you can't do that. It's they have the language of the rule is sincerely held religious belief. So this case is a good example of where sincerely held religious belief comes into conflict with not so much the rights of the store, but other other recognized rights of protected classes. And this is going to be an area of some friction for the time going forward. But just so you know, religious accommodation is what it really is. So religious accommodation requests from your employees, it has to be based in as I said, a sincerely held religious belief. And then that's something you're going to have to address on a case-by-case basis as it comes up. But it's a real issue, and it's going to continue to be a real issue. Proximity. Oh, yes. Okay.
Hey, John, I know we're at the 104, we're at 104 now.
Oh,
for your time. No, that's totally fine. You can keep going, or, I'm going to send these slides out to people anyway. Okay. So it's totally up to you whether you want to keep going.
No, let's just keep rolling along here. I can't see how many slides I have left, and I did get talking there, but let me just move through a little bit and see if I can hit up a few. This is one big issue, obviously, that gets talked about a lot. So the affirmative action case, students for fair admissions, the question that everybody has and had on the employment side is this, how does this affect us? How does this affect employers? I would say at the moment, it really doesn't affect you. This involved slightly different issues involving institutions of learning that were receiving federal monies. This is not a rollback. This is not a rollback of DEI. It may in the future result in other decisions that do, but in itself, it did not have an impact that you need to go and address as an employer right now with respect to your affirmative action policies or your DEI policies. All right, that's for California. So, lastly, I'm sorry, I wanted to get this earlier, so I apologize. But yes, in a quick sum, this is the slide I entitled PTO Armageddon. In essence, 10 years ago, 15 years ago, we all thought it was a great idea to put all time off into PTO. It would just be easy, and we can keep an eye on it, and we just say, okay, you get your 10 days, your whatever days, and call it what you will. It's PTO. We're done. What's happened since, unfortunately, is many states and many cities, New York being one of them, have developed these huge regimens of leave time. And they're so broad that the problem becomes, if your employee starts taking PTO time and uses it all up in, say, the first 6 months, they're still entitled to all of these codified guaranteed leave days. So as a result, you get trapped because you just have to give them more and more and more time. Because what employees will do is they'll just blow through all their PTO in the first quarter, and then as they need, say, personal time to do X, Y, and Z that's covered by these rules and statutes, you have to give it to them too. So the point of PTO, which is to simplify this, isn't really working much anymore. Many states, including New York and New Jersey, have now paid sick leave, and that has to get baked into PTO policies as well. there is a movement away from a single block of PTO and back to where we were before, which is separating these things out: sick time, vacation time, etc. Because it's almost unworkable in certain states because they've been so aggressive on leaves. So if you are struggling with PTO and how to handle it in this context, you're not alone. That is a trend that's been going on for several years now. And there is no easy answer. There's no clean answer. It's really going to come down to what is most efficient for your organization in terms of administrative time and looking, trying to keep track of all of this. And also the problem with employees taking advantage of blocks of time that they're guaranteed and taking leaves they're also guaranteed by the state or city that they work in. So I wish I had a little bit more time for that. It's a tough issue. As I said, there's no easy answer, but I do think that it may be the ultimate outcome is ultimately going to be that PTO gets broken up into bits and pieces again, like it used to be years ago. Administrative headache, but there it is. So good. Well, on that happy note,
less of a headache than this new headache.
oh, it's terrifying, particularly in my region, New York City. If you took every leave that you could potentially be entitled to, I think someone worked it out at something like a month and a half between bone marrow and voting and going to certain hearings that you're entitled to go to, etc. So it's well meant, it's well-meaning legislation, but it certainly doesn't make it easy for. Yeah, it makes it very difficult for HR to keep up with that in general. Anyway, any other questions that you saw? I can't see them from my screen.
No, that was it. You've answered every question that was submitted. I say every time every time we do these that I just don't understand how HR people keep up with all these changes. And like you said at the start, there's so many new updates and stuff right now, especially in the last couple of years and with remote work and stuff like that. So we're going to try to, help you guys along the way as much as we can. I do just want to say I put in the chat that there is an AI in the workplace for employers webinar coming up on August 9th. So you can find all the information out there. And John, I just want to say thank you so much for coming on and doing this. It was such a pleasure. And even I learned so much. I'm sure other people did too. So we really appreciate it.
Well, thanks, Amy. No, I really appreciate it. It's a very broad topic, obviously, and I hope I didn't go too fast or get too far in the weeds on some and not far enough on others. But
no, I think maybe you'll come back and we can go deeper.
Yeah,
into some of this stuff.
Yeah. As long as people just this is the time to be on your toes, vigilant. For years and years, not much happened in the area of HR that we couldn't easily keep track of. Now things are coming at a pretty blinding pace. So this is not a time to hold back on your HR compliance.
Absolutely. And I put John's contact information in the chat. I'll put it in the follow-up email as well. If you need to get a hold of him for anything or you're interested in his services, please feel free to contact him. Or if you have any questions for me, always feel free to email me. And I hope everybody has a great day. Thanks again.
Amy.
Okay, bye-bye.
Thank you.